and I explained it to her. The next day when I saw her, she asked me for the papers. She's like, we are done.
All right, so we're going to excuse you both. Sir.
No, I'm gone. Sir. I don't have that time to waste.
I think we could see what he did.
This is what I deal with every day. I don't think he wrapped tight.
We're going to excuse the parties while we deliberate in this matter so you can step out.
Okay.
First of all, I believe that in the beginning, at least, there was an agreement. And that she really didn't pay him in the end because she felt he didn't carry through with his portion of the agreement. So therefore, it was a breach of contract and she wasn't going to pay him, but gratuitously, she gave him $50. He says, no, I did all I could do but file, and the reason I couldn't file is because of this fee waiver issue, and courts don't accept a fee waiver without the actual party being present, and I would have had to at least have a home address for the party. Since she refused to give me the home address, she was not permitting me to complete my obligations under this contractual agreement, and so I didn't breach. She basically was the one that breached by failing to cooperate with this whole thing. So I don't think we should pass judgment on a $250 fee that might have taken transportation filling out. I'm willing to give him his $250, not give him the $250 for filing, and of course I don't see anything that she did to intentionally prevent the contract.
I'm not saying, of course, that simply because it's a form that he wouldn't have had the expertise to do the work, but in fact, he abandoned the project out of impatience. And therefore, leaving the defendant in the lurch about getting this done herself.
But she couldn't have done it without him filling out the paperwork.
But I'm not sure about that. She got it done when she went to the clerk and she found a clerk who was patient enough to walk her through the documents. Right. The document that was actually filed and got the job done, she prepared. One other point, though, if you look at his complaint, he said that the reason that the paperwork couldn't be filed was that she refused to provide a home address.
That's correct. That's what he says.
But it's not true because there was a P.O. box.
Yes. But the reason why he couldn't file with just a P.O. box, he never told her. That's why when she went down personally, they accepted it.
Another reason why I'd give him nothing.
Well, she gave him $50. I assume he has the $50.
Yeah.
No,
he gave it back. He gave it back.
Oh, he returned
was insulted by that.
I'd give him $50.
See, I feel like he did the first part.
I'd give him another $100 for his hour and a half that he spent.
He didn't get the job done. I'd give him $50.
I don't want to give him nothing. I think 50's too little. I do think that he did what he could on the paperwork. He did go down to the courthouse. There's evidence, obviously, that he's been down to the courthouse twice, ready to file the papers. $150.
I would join.
I dissent.
I would join, Judge.
Okay, $150. What'd you say, an hour and a half worth of work? That's fine.
I'm dissenting.
Okay. You know, when you take on a legal obligation, some clients are easier to deal with than others. Some listen better than others. And you can be frustrated in the process. You could be frustrated in a courtroom that you think that you're not being heard or that people are not looking to do the right thing. But what you can't do as a professional, and you're holding yourself out as a professional, sir, what you can't do is throw your hands up in the air and say, I'm done. And on the other hand, when people agree to things, they need to be clear about what they're agreeing to. You need to understand, and if there's a glitch or a problem, you need to clearly explain it to the layperson. And I'm going to put you as the professional here, sir, and Ms. Gauthier as the layperson. You need to explain what's going on and why. Why is this a problem? Why do you need to do this? Because people just don't want to give up things. They hold tight to protect themselves. So the bottom line here is we are unanimous in thinking that you deserve something for the work that you did, but we're not unanimous on the amount that we feel you're entitled to. So Judge Acker has dissented on what Judge Corriero and I felt were the value of the services, the limited services that you provided the defendant. We feel that the services you provided, the traveling, the going to the courthouse, the filling out the paperwork in part, the calls back and forth, was worth $150. We didn't see that you earned the $250 for the filing because ultimately the filing was done by the defendant. We certainly, none of us agreed that you're entitled to punitive damages or bad faith damages from the defendant's behavior because we didn't see any of that action on her part. Judge Acker feels that the work that you did was really worth what she gave you, $50, a gratuitous thank you as opposed to work actually performed. However, the verdict here is about 2 out of 3. Judge Corriero and I are willing to give you $150 for what you've done. That is the verdict of this court, sir. You get $150.
Did you see
and
that
don't
my
ever
documents
insult
were
us
prepared
again.
at 6:15 and she filed them 8.
And don't ever insult us again by walking out.
I'm walking out now.